Judgment in the matter of Actavis UK Limited and others versus Eli Lilly and Company.
The issue on this appeal is whether 3 products manufactured by Actavis would infringe a UK patent owned by Lilly and its corresponding versions in France, Italy, and Spain. The patent relates to a chemical called pemetrexed, which has therapeutic effects on cancerous tumours, but also has seriously damaging side effects. The patent discloses that these side effects can largely be avoided if a pemetrexed compound, pemetrexed sodium, is administered with vitamin B12. Such a medicament has been successfully marketed by Lilly since 2004. Actavis's products also involve pemetrexed compounds being used together with vitamin B12 for cancer treatment. However, rather than pemetrexed sodium, they include pemetrexed acid, pemetrexed tromethamine, or pemetrexed potassium. Actavis contend that because their products do not include pemetrexed sodium, the patent would not be infringed. At trial, Mr. Justice Arnold decided that none of Actavis's products would infringe, i.e., they would not of themselves infringe the patent in the UK or in France, Italy, or Spain, because the patent only extended to pemetrexed sodium. The Court of Appeal allowed Lilly's appeal, but only to the very limited extent of holding that the patent would be infringed only if Actavis's products were dissolved in saline, so that they resulted in pemetrexed sodium in the solution, i.e., indirect infringement. Lilly appeals to the Supreme Court against the holding that there would be no direct infringement, and Actavis cross appeals against the holding that there would be indirect infringement. The appeal raises 2 issues of principle. First, the correct approach to the scope of patent claims, and secondly, the permissibility of referring to the prosecution history of a patent when determining its scope. The Supreme Court unanimously allows Lilly's appeal and holds that Actavis's products would directly infringe the patent in the United Kingdom and also in France, Italy, and Spain. Actavis's cross-appeal against the finding of indirect infringement is unanimously dismissed. Direct infringement. The Protocol on the Interpretation of Article 69(1) of the European Patent Convention makes it clear that first, the scope of protection afforded to a patentee is not to be limited to the literal meaning of the claims. Secondly, that there can be a difference between the interpreted scope of a claim and the scope of protection afforded by it. And thirdly, that when considering the scope of protection, so-called equivalence must be taken into account. Whether an item directly infringes a patent is best approached by addressing 2 questions, namely A, does the item infringe any of the claims as a matter of ordinary interpretation? And if not, B, does it nonetheless infringe because it varies from the invention in a way which is immaterial? Only if the answer to either question is yes, is there an infringement. On question A, according to normal principles of interpretation, Actavis's products do not infringe the patent, which is limited as a matter of ordinary language to pemetrexed sodium. On question B, when considering whether a variation is material, the following questions should normally be considered by the court. 1, does the variant achieve substantially the same result in substantially the same way as the invention? 2, would it be obvious to a reader of the patent, knowing that the variant achieves substantially the same result as the invention, that it does so in substantially the same way as the invention? 3, would such a reader have concluded that the patentee nonetheless intended strict compliance with the literal meaning of the relevant claims of the patent? There is infringement in such a case if the answer to the first two questions is yes, and the answer to the third no. Turning to the facts of this case, Actavis's products directly infringe the patent. 1, they all involve a medicament containing pemetrexed and vitamin B12, and they achieve substantially the same result in substantially the same way as the invention. 2, knowing that Actavis's products achieve substantially the same result as the invention, the reader of the patent would have thought it obvious that this was achieved in the same way as with pemetrexed sodium. 3, the Court of Appeal had placed too much weight on the words of the claim. A reader of the patent would not have concluded that the patentee could have intended to exclude any pemetrexed compounds other than pemetrexed disodium from the scope of protection. Direct infringement is also established under French, Spanish, and Italian law. Recourse to the contents of the prosecution file when interpreting a patent or the scope of its protection will only be appropriate if they clearly resolve a genuine ambiguity in the patent, or if it would be contrary to the public interest to disregard the file. The contents of the file do not justify departing from the conclusion arrived at in this case. In these circumstances, Actavis's cross-appeal does not arise. However, the Supreme Court would have upheld the Court of Appeal's determination that Actavis were liable to Lilly for indirect infringement. Thank you for coming. The court's now adjourned.